Welcome to today's Yale Law School event focused on the Grande-Synthe case from the French Conseil d'Etat. This case is being seen, this decision is being seen as a major breakthrough for court-driven climate change action. And we're privileged today to have three justices from the French State Council, as it might be translated, best really understood for those in the Anglo-American legal tradition as the Supreme Court for Administrative Law in France. I'm Dan Esty, a professor at the Yale Law School and also at the Yale School of the Environment. I'm going to be the moderator for our discussion today, and I really hope it will be a discussion. And I want to thank you for joining us from all over the world for this event. And on behalf of our co-sponsoring organizations at Yale, the Yale Center for Environmental Law and Policy, our Global Constitutionalism Symposium, the Gruber Project on Global Justice and Women's Rights, the Yale Environmental Law Association, and the Yale Law School European Law Association for being part of this discussion on a topic of enormous importance. We are going to have the three panel presentations at the outset, some commentary, and then I do hope a discussion, and that you will give us your thoughts, comments, and questions through the Zoom Q&A function. It is, of course, a tragedy. We cannot welcome you all to New Haven and to our school, but this is a virtual opportunity that perhaps gives us broader reach as a result of our pandemic moment. We do have a global audience of some hundreds of participants from the world of law, from business, students, professors, lawyers, judges, justices. And it really is a pleasure to welcome you all. So let me start by saying to our panelists from France and all those in the Francophone world joining us today, bienvenue. And to others joining us from across Europe, Africa, and Latin America, bienvenidos, or willkommen. And to our colleagues in Asia, some of whom are staying up very late to be with us, in Japan, yokoso, and in China, Wanying. Our program today really is a chance to reflect on an extraordinary year, really 16 months, of climate change jurisprudence in France and really the framing out of environmental rights more broadly. Beginning in October 2019 and continuing to this very month, the French legal system, the French judiciary, has been pushing the frontiers of climate change protection in a way that no other court system in the world has. And that's the focus of our discussion today. And we do want to reflect particularly on this Grande-Synthe case, but also look back at what the French Constitutional Council has done with its decisions in the Total case, the UIPP case, the Mobility Orientation Act. And it is a special pleasure to have the president of the Conseil Constitutionnel, Laurent Fabius, as an ongoing participant in our Global Constitutionalism Symposium that you'll hear a bit more about in a minute from my colleague, Judith Resnick. It is clearly the case that France's emerging judicial sustainability leadership is of great evidence in the Grande-Synthe decision, but it's also plainly apparent in the L'affaire du siècle, the case of the century, that's just come out from the Paris Administrative Tribunal. In this case, holding the French government accountable for moral and ecological damage for failing to curb greenhouse gas emissions. So we have much to talk about today. And before jumping into the substance, I want to just turn the virtual microphone over for a moment to our Yale Law School Dean, Heather Gerken. Heather.
Thank you, Dan. I am so honored to be able to be part of this program and to welcome all of you here. I just want to thank all of the co-sponsors, especially the Yale Center for Environmental Law and Policy and its wondrous director, Dan Esty. He is an inspirational figure. He moves effortlessly between academic life, the private sector, and policymaking. And today I learned that it turns out he's polylingual. He's been working on a successful response to climate change and sustainable future. And I think I'm getting a little bit of I think we fixed it. And of course, I just want to say a special thank you to the members of the Conseil d'Etat who are joining us here today. Vice President Bruno Lasserre, Fabian Renault, and Stéphane Hoynck. We're so delighted to host you today, even if it is via Zoom, and that we want to just welcome you into New Haven and to this school. So I won't spend any time talking to you about this extraordinarily important case because we want to leave that to you, but we know that it's initiated an extraordinarily important dialogue in France's civil society, judiciary, and administration. And we're so grateful to have three members of the court joining us here today. I'll just note that today is the latest in a series of discussions at our law school about global constitutionalism and international sustainability. In recent years, the precarious future of our environment has become an increasingly urgent focus of our annual Global Constitutionalism Seminar, chaired by the remarkable Judith Resnick, who will be giving remarks today. Only Judith could assemble so many stars from the judicial galaxy and inspire them to speak as candidly as they do. As part of the conversations that take place every year during that seminar, the jurists, scholars, and lawyers convened by Professor Resnick have been grappling with the role of courts in addressing the fragility of our environment. And today's guest will undoubtedly deepen our understanding of how the law can shape our commitments to a sustainable future and what remedies courts can and should provide. I'm also delighted that Professor Doug Kysar will serve as one of our respondents today. His remarkable work has focused on how climate change challenges the basic capacity of legal systems. It has been a clarion call in the field. And it's not surprising that Doug has taken up these issues as his life's work. His ethical commitments and basic decency are such that he has long served as one of the consciences of the law school. And now he serves the same role for the world. Despite his painfully keen awareness of law's limitations, Doug has argued that courts have an ethical duty to act and not to surrender in the face of global catastrophe. The Conseil d'Etat is one court that has not refused this responsibility. And I know we all eagerly await today's discussion. So now with delight and gratitude, I'll hand things back over to Dan.
Thank you, Heather, so very much. It's now really a pleasure to introduce my law school colleague, Judith Resnick. Many of you who have been following global constitutionalism know that it is Judith who chairs and leads our Global Constitutionalism Seminar and Symposium each fall. She is also the head of our Gruber Project for Global Justice and Women's Rights. So Judith, you're welcome to our program, please.
First of all, thank you very much. And it's a pleasure to participate. And bonjour, Dan's French is so much more fluent. I can read and consume, but when I start speaking for the French among you, I would be painful to your ears. So I will switch to English, but I'm happy. We were just a few years ago guests of the Conseil d'Etat. And when we were there, we had an exchange in which some people spoke French in French, and some of us heard in French and responded in English. So we're very grateful for all that we've learned. I have the wonderful volumes from the Conseil d'Etat that provide an overview annually of the work, and I am on your e-list, so I get to personally thank you, Chief Justice Lasserre, for your wonderful outreach efforts and your accessibility and your informing us. And it is the case, and here I can thank both Professors Kysar and Esty. Over the last few years, global constitutionalism has devoted questions and topics and materials to this question, to what France is pioneering, which is the relationship of courts to the fragile environment. And we have ebooks that are available without any charge on the website at Yale, with chapters that are co-authored and materials gathered by the president of the Conseil Constitutionnel and by the professors here and by others in the group. So we welcome and invite people to use the materials that relate to these topics. And I think I see that they're available in the chat. And so one is to thank you. A second is to say, we look forward to continuing at the Conseil d'Etat, with the Conseil d'Etat going further. And third, at a very parochial level, the timing is exquisite because students at Yale Law School tomorrow in a class I teach about federalism in the United States and the court system are reading cases in which environmentalists went to the courts. Our court recognized environmentalism could be a harm, but then have been very limited in being willing to engage in it. So my welcome is to say, thank you for giving us an understanding of the potential for courts to engage creatively in a dialogue that is iterative and to which judges are among the important contributors. So merci.
Judith, thank you very much. It really is a joy to have this opportunity to continue that global constitutionalism conversation today. And with that, I want to turn to our panelists and introduce first Chief Justice Bruno Lasserre, who is going to provide us with initially an overview of the French administrative justice system, and then opening remarks on this important Grande-Synthe decision. Chief Justice Lasserre has spent 40 years in public service, including important roles as the Director General for the French Post Office and Telecoms, a role as President of the Competition Council, and in enormous ways has contributed to the French judiciary in his 3 recent years as head of the Conseil d'État that we're going to hear from today. He will be joined in the commentary from 2 of his colleagues on the court. And in that regard, we welcome Justice Fabien Raynaud, who is the head of the 6th chamber, and that is within this structure, the one responsible for environmental cases. Justice Renault is a graduate of the École Nationale d'Administration, so the ENA, the famous training ground for French public servants. He's a European affairs specialist. He's been posted in Brussels, and he served as the special advisor for European affairs to the president of France for a number of years, 2007 to 2012. He will be joined by Justice Stéphane Hoynck, who is a member of the 6th chamber as well. He was the public rapporteur for the Grande-Synthe case, and it is to him that we are grateful for having given us the translation that allows us to circulate the decision and really provide the foundation for the discussion today. But with that, let me turn the virtual microphone over to Chief Justice Lasserre. Chief Justice, I think you are still muted. Will, can we unmute him, please?
I'm asking to do that now. Here they come.
Is it okay now? Okay, so thank you very much for your kind words. It's a great pleasure to speak to you tonight about the Grande-Synthe case, which will be at the center of our conversation during this webinar. And thank you very much to the Yale Center for Environmental Law and Policy and his partners. Thank you to Dean Heather Gerken. Thank you to Professors Daniel Esty, Judith Resnick, and Doug Kysar for organizing this webinar. The Grande-Synthe case decision, which has been handed down on November 19, is undoubtedly novel and innovative in many ways. And I won't have time to deal with all the questions it raises. I will maybe focus on maybe the main 3 questions I think are the most relevant to launch these panels, this conversation. The first of this question is, why judges and why are climate change issues beginning to come before judges? And my answer would be because there is a movement and because there is a frustration. There is a movement first. Throughout the world, climate concerns have continued to grow, and these concerns are certainly old, but I believe we have reached now a turning point. And because the facts speak for themselves, the idea has emerged that it is no longer possible to wait. We are facing a sort of climate emergency that people in good faith can no longer ignore. And there is a frustration under pressure from public opinions, from citizens, from NGOs and associations, from communities. Governments have made strong commitments. They have multiplied public declarations, signed international agreements. They have adopted strong-willed legislation. And this is obviously the case. But this is no longer enough. What citizens want today is for these commitments to be effectively implemented. And to ensure this effective implementation, more and more citizens are turning to judges, independent judges, who they hope will force the governments to act. Judges who they hope will transform climate change law from a sort of soft law with fuzzy political promises to a hard and binding law. Of course, this shift is open to criticism, And some fear, especially in maybe political and business circles, fear that judges are legislating in place of elected representatives. The threat of judicial activism is regularly raised. And I think these fears are legitimate, but I believe they are unfounded. If judges are solicited, it is above all because governments have made commitments and transposed these commitments into legislation. Judges are called upon to hold governments accountable and to draw the consequences, and only the consequences of those legal commitments. So if citizens are rushing in a certain way to courtrooms, it is because they understand courtrooms are not the place where we can design environmental policies, but they are the place, I would say, of political accountability. And judges, therefore, find themselves, they want it or they don't want it, at the forefront of the climate scene. In the same time, judges also find themselves in competition because the questions which are raised are global and because the reference standards which are invoked are international or at least continental. In Europe, we have in fact two kinds of reference standards with strong and weak points. On one hand, we have the famous Paris Agreement signed in 2015, which is very precise, especially if we take into account the national contributions which have been brought under the umbrella of this agreement, but not binding. On the other hand, we have the European Convention of Human Rights, and especially its Articles 2 and 8, which deal respectively with the right to life and the right to privacy. And this convention is not specific, very general, but it is a binding norm, a binding text. And given these differences, the ways in which judges draw climate consequences from these texts are naturally not the same. And if we look, for example, at what happened in the UK with the extension of the Heathrow airport, with the famous Court of Appeal case reversed by the UK Supreme Court, we have the use of the Paris Agreement. If we have a look in the Netherlands, we have this famous Gender Foundation case where the Human Rights Convention has been successfully invoked. My second question is, in this competition between judges, which allows a sort of forum shopping, why choose the Conseil d'État? And in my opinion, the Conseil d'État and in general the French administrative courts have important assets to play a driving role in this judicial environmental dynamic. The first of these assets are, I shall say, time and money. The Conseil d'État is generally quick to issue its decisions. It takes on average 1 year to judge substantial cases. And in addition, in cases where regulatory measures of national scope are challenged, you can go directly to the Conseil d'État as a first and last resort, a court. And of course, this significantly shortens the time needed to obtain a final decision. If I take the example of the Grande-Synthe case, the city was thus able to appeal directly to the Conseil d'État to challenge the government's refusal to take additional action to curb the greenhouse gas emissions curve. In addition, lawsuits before the French administrative courts are very inexpensive. Inexpensive because it's not necessary to be represented by a lawyer, and because it is the judge who conducts the investigation. Another asset is the ease with which it is possible to bring a case before the judge, particularly in what we call legality litigation. It means when you challenge an act, when you ask the judge to make a judicial review of a public decision. In this type of litigation, the standing to sue is indeed assessed in a very flexible way. It is not necessary to be a direct victim or to have suffered a damage to address the court. Thus, in the Grande-Synthe case, the mere fact that the location of the city, which is a coastal city, exposes it in some 20 years to flood risks was sufficient to make its action admissible. This assessment of the standing to sue is a French originality and an essential aspect of legality litigation, which distinguishes it from many of its counterparts, for example, the Germanic tradition, or even the jurisprudence of the European Court of Justice. A third advantage, finally, is that the Conseil d'État has significant powers to enforce its own decisions. It can, on the one hand, issue injunctions and determine the measures to be taken by public authorities to remedy an illegality. On the other hand, it can order them to pay a penalty if they do not comply with these injunctions. And in a recent case, dating back from last July, in an air pollution case, the Conseil d'État set a very heavy penalty to force the government to comply with its air pollution requirements, commitments. And this was a strong signal and an essential prerequisite to build up judicial deterrence for climate issues. These advantages are above all those of these procedures I call legality litigation. This procedure is really the trademark of the French administrative jurisdiction. But we cannot talk about the Grande-Synthe case without mentioning another very recent case called the case of the century, which has been already described. It dates back from February the 3rd and was decided by the Paris Administrative Tribunal. And what is interesting in both cases, in each of these cases, is that each of them took a different legal avenue. In the case of the century, the claimants chose to go through a traditional compensation litigation. Unlike the legality litigation, the compensation litigation is turned towards the idea of a redress. Claimants must first show their status as victims in order to be able to bring a case before a judge, which may not always be easy in climate matters. It is also necessary to demonstrate the existence of first the fault, second the damage, which must be not potential but actual, and third, and not the least, I would say, the existence of a direct and certain causality linked between the fault and the damage. Traditionally, the administrative courts retain a broad conception of fault, which can result from an action or an omission. The difficulty in climate change matters lies in the fact that more often than not, fault results not from total inaction, but from partial inaction. I mean, the administration has acted, but insufficiently. And a borderline between mandatory and desirable action is not always easy to determine. But in this litigation, the most problematic questions are those of damage and causality. In climate matters, this means that one must wait for the damage to occur before the government is condemned. We also know that the link between, for example, a particular flood, a particular forest fire, or an unbearable rise of temperature on one hand, and government's inaction to reduce the greenhouse gas emissions on the other hand, will always be difficult to establish. In its decision, L'Affaire du siècle, the case of the century, the Paris Administrative Tribunal in fact, finds the government guilty for not meeting the objectives it had set itself. Above all, and that's important, the decision admits that an action for compensation for what we call ecological damage is open against the government. And what these two decisions have in common is that they recognize that European and national regulations based on the Paris Agreement are binding, and that citizens, and that's very important, can directly invoke them against the government. They do not give the Paris Agreement direct effect in domestic law, but they clearly give them interpretative force. In the Grande-Synthe decision, the Conseil d'État thus interprets France's strategy for reducing greenhouse gas emissions in the light of these agreements, and rules that this strategy is not merely programmatic, which was not at all legally obvious. And the legality litigation and the compensation litigation nonetheless present two very different ways of challenging the public authorities' inaction on climate change. And the choice between these two avenues of law will remain a decisive factor in the litigation strategy of the claimants. This brings me to my third and last question. What is the control of the courts in climate matters? What distinguishes in particular these two avenues of law is the relation to time. In compensation litigation, the judge looks to the past. In legality litigation, the judge looks to the past, but also to the future. This is where the Grande-Synthe decision opens up new horizons by accepting to control the credibility of a trajectory, of a path, I would say, of greenhouse gas reduction. Judges suddenly find themselves projected in the long term of the fight against climate change. And this projection into the future is linked to the fact that by its decision, the Conseil d'État considers that it is not necessary to wait for the deadlines 2030 or 2050 that Europe and France have set themselves to reduce their emissions, to carry out its control and check whether the objectives in question are being met. On the contrary, it undertakes to scrutinize as of today that these objectives can be achieved by 2030 and 2050, to check that those objectives are credibly being met. And I think this is very innovative because we know the different layers of judicial control. We have the control of conformity, the control of consistency, and there appears a third layer, the control of reachability of binding objectives. And in doing so, the Conseil d'État assumes its responsibilities. Waiting until 2030 would be tantamount to denying the urgency of acting today. In other words, to wait until 2030 would have been to wait for the irreversible. And Stéphane Hoynck, in his public remarks on the case, quoted Mark Carney, the governor of the Bank of England, what he calls the tragedy of the horizons. And we have to avoid this tragedy of the horizons. I mean, avoid the irreversible. Now, a few words about what follows the two decisions. A new phase has begun, which will lead the Conseil d'État to say whether the current trajectory is credible. For the time being, it has only set the legal framework of its scrutiny, of its control, and asked the government to demonstrate that its strategy is compatible with the objectives it has set itself. So the government sent last Monday a brief. This brief will be, of course, transmitted to the parties for a contradictory discussion, and the final decision should be made before summer. The Paris Administrative Tribunal proceeded in a similar manner. It ordered a further investigation to determine whether the ecological damage which has been found can actually be repaired in kind and not in money. And beyond all that has been said, these additional investigations show that climate litigation requires and will require in the future very delicate, very technical assessments by judges. And for this, an in-depth contradictory debate is necessary. Possible avenues of evolution may have to be explored in this area. And now it's time to give the floor to Fabien Raynaud. As you told us, Fabien is the chair of the 6th chamber who instructed the Grande-Synthe case, and to Stéphane Hoynck, who was the public rapporteur on the case. Thank you very much.
Thank you very much, Mr. Chief Justice.
Hello.
Welcome, Justice Renault.
Thank you very much. And first, I'm very pleased to participate in this webinar and to have the opportunity to discuss with you on the Grande-Synthe decision, on which I had worked quite a lot. And so I hope that we will have a very interesting decision. So I will try not to be too long in my expose, to leave room for the discussion and for the exchanges between us. First, a very quick presentation of the case. As the Vice President just explained, it is a legality litigation. So the municipality of Grande-Synthe, a small town in the northern part of France, and its mayor asked in November 2018 to the government to take additional measures to reduce greenhouse gas emission, GHG emission. And then in January 2019, they referred the refusal, the implicit refusal from the government to the Conseil d'État. So here, so we are in legality litigation. Before developing on the content of the decision itself, I would like to recall also that this decision is a step decision that does not yet take a position on the merits of the request itself, but set the legal framework of the case. Still, I think it is a very important decision for three reasons. First, it expressly states that the municipality of Grande-Synthe is admissible to act. As the Vice President said, we have traditionally a flexible approach on the issue of admissibility on legality litigations. But here, the issue was not at all obvious, and it was a very disputed issue. And it was particularly important since it was the first legality litigation about climate change. And the difficulty was to avoid two pitfalls, to be too open in a way that anyone would be admissible to act in this field, since climate change potentially concerns everyone. And of course, it would not have been reasonable. Second, to be too demanding, so that in fact nearly no one would be admissible to go to before the judge, except maybe the Environmental Association, which would not have been a very satisfactory approach either. So we have tried to find a balanced approach. And it's why, on the one hand, we have estimated that considering Grande-Synthe's geographical specificity, a coastal city, partly below sea level, very exposed to flood, with clay soils, etc. So on the basis of all this geographical specificity, this city is particularly exposed to the consequences in 20 or 30 years from now of climate change, and should therefore be regarded as admissible to act against the refusal to take additional measures to fight against climate change. On the other hand, we have estimated that following the same reasoning, a person who simply indicates that he lives today in that city is not admissible to act, because if we had say the contrary, it would have opened too much, we believe, the access to the judge. So then the second reason for the importance of this decision is that this decision sets a legal framework for the case and more broadly for the litigation on climate change in France. The difficulty on this point was that the norms invoked, which was the Paris Agreement and the domestic law adopted for its implementation, had, to say the least, an uncertain legal value. The Paris Agreement clearly does not have direct effect in French law, and the Conseil constitutionnel ruled in 2015 that the law setting the objective of minus 40% of GHG emission by 2030 was a purely programmatic law and therefore was not legally binding. Nevertheless, we have considered that the domestic law implementing the Paris Agreement had to be interpreted in the light of this agreement. And this agreement are based on the principle of common but differentiated responsibilities of the parties and make of national contribution the central element of the whole mechanism. So we have deduced from that the provisions of domestic law which expressly implement the Paris Agreement should be regarded as legally binding. And I think it is the boldest aspect of the decision and the key point, because the consequences of that is twofold. Not only the reduction objective set by the law for 2030, both at national level and at European level, and the two legislative are converging at the same objective, is legally binding, but also the mechanism put in place in France, in French law, to define the trajectory to reach this objective, which is what we call the carbon budget, which sets a ceiling of the GHG emission for multi-year periods and are established by decree, are also legally binding. And finally, the decisions indicate that the legality of the challenge refusal will be assessed with regard to its compatibility with the trajectory set by the carbon budget, as defined by the 2020 decree. And we noted that the 2020 decree modifies the trajectory, postponing the essential part of the effort to reach the 2030 objective on the post-2020 period and even more on the post-2023 period. And it's why we gave 3 months to the government to provide any elements to assess this compatibility. And as the Vice President said, we have received Monday the elements sent by the government, and their elements were immediately transmitted to the applicants, and they have 1 month to send to us their observation to this new element. And we will still have to take our decision on the merits of the requests sent by the municipality of Grande-Synthe, probably during this summer, and which will lead us to make an assessment that will be very technical. The question, is this refusal compatible with the trajectory, is a more technical issue, in fact, that a purely legal one. but it will probably be an assessment very complex, and which will demand from us a very complex assessment. In conclusion, I've been already too long. In conclusion, I would like to insist on the fact that our decision gives the Paris Agreement and the national norms taken to its implementation a central place and a full legal effect. And this seems crucial to me for two reasons. First, it reduces the risk of subjectivity by the judge, since the judge has only to verify the respect of the objective set by the legislator, which is, I think, respectful of the democratic principles. Second, it is consistent with the global logic of the fight against climate change, since the Paris Agreement is the only global instrument at our disposal. And I believe that this approach can be replicated in other state parties to the Paris Agreement, and that in the absence of a supranational judge on this issue, this way forward is, I think, to me, the best possible way forward for this kind of litigation. I thank you for your attention.
Justice Raynaud, thank you very, very much.
And I leave the floor to Justice Hoynck.
Yes, Justice Hoynck, we welcome you.
Hello to everybody. So my position on the Grande-Synthe case is particular, since my duty was to give my personal and independent opinion during the hearing of the case. And this position allows me to discuss briefly an element that was very much discussed by the parties, but that is not mentioned in the Conseil d'État ruling, and that is the human rights dimension. The applicants invoked human rights principles in their plea, and especially, as President Lasserre mentioned it, Article 2 and Article 8 of the European Convention on Human Rights. And in particular, they made explicit references to the Dutch court rulings in the Agenda Foundation case. In my view, the possibility to utilize human rights principles in a climate change dispute, such as the French one we had, was a tough nut to crack. Until now, the European Court of Human Rights only applied Article 2 and Article 8 to situations where a particular risk to life or to the well-being of people was identified, and even more important, where a particular line of action by governments was identified, and a line of action that was able to stop such risk for the population. A typical situation is a polluting plant that might intoxicate neighboring communities. A government can put in place stringent regulations to limit toxic emissions, and it must enforce such regulations. Or in other cases, it might take measures to displace residents to protect them from such hazardous environments. And failure to take such appropriate measures may lead to a breach of Article 2 or Article 8 of the Human Rights Convention. And the case law from the ECHR is very rich in that respect, as you probably know. Climate change, on the other hand, is undoubtedly also a major threat, but it's a global one, and it is not obvious to identify how a particular course of action by one national government might prevent such a risk from happening, even only taking into account the safety of its own residents. This difficulty led me not to propose a ruling based on human rights principles. But as was mentioned by both President Lasserre and by Fabien Raynaud, there was in the French case a more straightforward, maybe a bold, but straightforward way to control the climate change policy of the government using the obligations that were laid down in EU and French law. And that's the reason why the ruling does not discuss the issue of human rights. But I would like to point out that by extending with the solution elaborated by our Dutch colleagues, I'm not suggesting that our solution is necessarily a better one. And I'd like to insist on 2 points here. The first one is about a difference of nature between the French and Dutch cases. Looking at things from a very broad angle, you might consider that in both cases, the claimants complained about insufficient action to curb global warming by their national government. But in the Agenda Foundation case, what was at stake was the definition of the appropriate targets to cut down greenhouse gas emissions. It was a question of level. In the French case of Grande-Synthe, as you have understood, the appropriate target was not very seriously discussed. The purpose was not to have a higher bar, but to make sure that the government was putting in place the right strategy, a coherent roadmap to achieve this target, especially the 2030 targets. So what we have here is a shift from a duty of care based on Article 2 and 8 of the ECHR to a duty for the government to implement explicit legal provisions. And this shift from one case to the other can partially be explained by a difference in what was expected from the government in the plea by the claimants. The second and final point I wanted to mention is not a point of difference, but a point of convergence between the French and the Dutch cases. I have said that it is difficult to figure out a precise causation between a lack of national ambition to curb global warming and harm caused to a national population because of this lack of ambition. Indeed, what other countries do or not have a greater impact on global warming and on the condition of existence of French people because of global warming. A greater impact than the actions of the French government, however righteous or negligent they are. France is, after all, responsible for only 1% of the worldwide greenhouse gas emissions. But these factual elements do not lead to the conclusion that there is no necessity for each individual country to act and for national courts to check if national governments make sufficient efforts to meet these required targets. This element was central, obviously, in the agenda case, and it was somehow accepted without discussion in the French case. But I think that it is a line of reasoning that we necessarily embraced when we accepted to control right now that the French government has a credible roadmap to achieve its 2030 target. Indeed, what is important is to make all efforts to reach this goal in due time, instead of waiting for 2030 and maybe try only then to find ways to correct insufficient actions. So, talking about climate change is important, making substantial pledges to tackle this problem is even more important, but actual climate action is the end goal. So you see that the Grande-Synthe case brings the climate change debate one step further in trying to address the effective implementation of the Paris Agreement national contribution. I could be talking about many other aspects of this litigation, but I believe that my colleague, just like me, are eager to engage in a discussion with you, so I may well just finish now and leave the floor for questions. Thank you very much.
Thank you very much, Justice Hoynck. I'm going to turn now to my colleague, Doug Kysar, and invite him to offer a commentary from a U.S. perspective.
Thank you, Dan. I want to thank the sponsors and organizers of this event, and I especially want to express my gratitude to the justices of the Conseil d'État who have joined us to discuss this decision, which does indeed have enormous significance for climate governance in France, in Europe, and globally. Like the other speakers, I'll keep my remarks brief so that we can maximize our time for questions and answers. I do need to stress that my remarks are coming as someone without expertise in the French court system, so please take them as the words of an admiring but underinformed outsider. The first thing I want to stress about the Grande-Synthe decision itself, at least the unofficial English translation that I read, is that it's quite technical and it consists mostly of dismissals of various claims brought by the municipality. As mentioned by the justices, unlike the famous Urgenda decision in the Netherlands, the Conseil d'État did not directly rely on the European Convention of Human Rights and did not expressly recognize a general enforceable right to protection against climate change. The claim in the decision that is not dismissed is also not granted in full on the merits. Instead, the government is ordered to respond within 3 months, explaining how it will achieve its greenhouse gas emission reduction targets despite missing recent benchmarks and despite the order of April 2020 during the early months of the coronavirus pandemic, which delayed implementation of emissions reduction responsibilities. So from one perspective, we could see the decision as rather narrow in its scope and impact. The government is ordered to explain how it will achieve its own previously announced climate change commitments in light of some apparent backsliding. But from another perspective, the ruling is quite breathtaking in its scope and impact. It is administrative law on steroids. Grande-Synthe, the complaining municipality, is deemed to have standing to request additional greenhouse gas reduction measures from the national government. And the Conseil d'État expresses its authority to review the government's refusal to grant Grande-Synthe's requests. Climate accountability is thus imbricated both vertically and horizontally through the process. The demand for an accounting from the government is also quite courageous as a judicial act. The justice has already described how challenging it will be to engage in the decision of whether the government's response to its order is convincing. But what happens if the government does fail to respond convincingly? What orders could possibly follow next? My understanding is the Conseil d'État does not understand itself to have the power to order the government to submit bills to Parliament. Thus, the court might be forced to engage in a sort of micromanagement of regulatory measures that may be derived from the existing climate legislative scheme. Will the court want to proceed by injunction? And if so, how will it do so if we're talking about climate policies of a multidimensional nature that need to be strengthened, altered, or made more effective? Federal courts in the United States have gotten quite good at avoiding such interbranch showdowns, instead invoking various procedural or jurisdictional doctrines like standing and political question in order to shy away from confronting grave challenges like climate change. In the United States' own famous climate change case, Juliana versus United States, the Ninth Circuit Court of Appeals went so far as to say that the youth plaintiffs in that case lacked standing to press their constitutional claims because a declaratory judgment would not offer the plaintiffs meaningful relief. In other words, the court in Juliana assumed that its own declarations regarding a constitutional right would be ignored by the other branches. In contrast, the bravery and confidence of the Grande-Synthe decision is notable and refreshing. One imagines that it will serve as an inspiration to many other courts. Most importantly, one hopes the European Court of Justice, which has been slow to support the normative significance of climate change commitments. It also bears highlighting that the decision was undertaken amidst multiple crises, not only the climate change crisis, which is at issue in the case, but also the coronavirus pandemic and the continuing civil unrest of the Yellow Vest movement, a movement that one might expect will greet the Grande-Synthe decision with concern. For the justices to nevertheless stand firm and issue this judgment during these times is nothing short of extraordinary. Now, this brave and responsible orientation toward judging is consistent with a function I've called prods and pleas, a corollary to the more familiar function of checks and balances. Even when a social need exceeds the scope or the capacity of a court, the judge may still acknowledge the seriousness of that need and the desirability of action by other more appropriate actors. Just as the existence of divided and overlapping government authority creates opportunities for those institutions to check and balance one another's overreaches, it also opens space for them to plead and prod with one another when the danger instead is one of government underreach. Now, there's one final thing I want to emphasize before I wrap up. As I mentioned before, a layperson reading the order would likely miss its great normative importance, given how technical and seemingly narrow it can appear. In that light, I found the accompanying press release issued by the Conseil d'État to be a most striking document. The press release begins by noting the historic nature of the decision. It reads, "For the first time, the Conseil d'État has had to rule on a case regarding the fulfillment of France's commitment to reduce greenhouse gas emissions." The release then explains in plain, accessible language the actions being taken by the court. The statement seems to have been released in both French and English and appears to have been highlighted via the court's Twitter account. Not surprisingly, the release was picked up by newspapers, radio programs, bloggers, and others the world over. So from the outside, it looks like a rather sophisticated and intentional effort to use public relations in furtherance of the court's normative authority. If time permits in the conversation, I would love to hear from the justices about how they view the press release in relation to their function and impact. Thank you.
Doug, thank you very much. And in the spirit of making this a fluid conversation, I'm going to put 3 more questions that have come in to our justices, and then invite them to comment on any or all of the ideas that have been put in front of them, including Doug's comments and his question to you. But if I could, I'd like to offer another question, a related question from our colleague at the Yale Law School, Susan Rose Ackerman, who was asked, what is the remedy that the Conseil d'Etat will propose if the government response continues to be judged inadequate? And from another Yale colleague, Bruce Ackerman, a related question that is, in what ways is the Conseil going to be able to make that judgment about the adequacy? Does it have access to environmental, sustainability, scientific, mathematical, or statistical expertise that would allow the justices to have a line of sight on the adequacy of the government's position on climate change? And then from Jonathan Weiner, professor at the Duke Law School, a related further question about the authority of courts generally, and the Conseil d'Etat in particular, to order government action. Professor Weiner notes that this has been a point of contention, as Professor Kysar just pointed out, in the Juliana case. There's been a sense in the United States that courts are not in a position to order government action. However, in the Urgenda case in the Netherlands, the court did order such action on the part of the Dutch government. And in the Pakistan Leghari case, the court also took an expert body to advise it, took on board an expert body to advise it on climate policy and actions. So Professor Weiner would like to know how the Conseil d'Etat might respond in a similar way. And again, I invite all of you in our participating audience to send questions in through the Q&A. But justices, your thoughts or comments in response to any or all of this, please.
Yes, hello. Maybe I will try to answer on the first one, the first question about the press release. It's quite an unusual question we have. I know that when we make a decision, there is always a debate between the justices and the press department about how precise, how legal the vocabulary used in the press release should be, and the tendency, the willingness to make it understandable by the general public is sometimes felt by the justices as too much of a compromise, because we try to be precise and accurate in the way we formulate things in our decisions. So if in this case the press release was understandable, especially for an audience that is not familiar with French public law, I guess that's a welcoming result we have here. The second question is about remedies in case of if the action of the government turns out to be not satisfactory at the end. Maybe I will answer this one too, or you? Okay. We had, as President Lasserre mentioned before, we had a case, Friends of the Earth France case last year in July about air pollution. And in this case, we already had a previous decision by the Conseil d'Etat in 2017, where we basically found that the government was not taking enough action to curb the air pollution problem, especially nitrogen dioxide and other pollutants of the air that have effects on the environment and on human health. And so the 2017 case ordered the government to take better action, to have more efficient plans to curb these air pollution emissions in the areas of France, in Paris and other areas where this level were too high according to EU legislation. And sometimes later, we just had the situation where the government did not comply with the order of the court. The efforts made did not reach the results that was expected. So that was the case we had last summer in July in the Friends of the Earth case, where we made an injunction to the government to do what was already required previously, and we added to that a penalty, a strong penalty, as the President Lasserre mentioned, to force them to act. So what we did in the air pollution case is a possible outcome if we end up in the climate change case to consider that the government is not acting enough. So making penalties is probably not a very satisfactory decision. It won't solve the problem, but it's another impetus for the government, another pressure for the government to act. And that's where we are at the moment in terms of being able to find remedies in case of continuous inaction or inadequacy of the solution made by the government. The next question is a bit prospective about the tools we have for assessing what's in the matter. Fabien, as you would like. It's a tricky one. It's not the reason why I'm turning it to you, but
well, it's a difficult question because, as I said, we will have to assess the legality of the decision through a very technical assessment and very technical and complex assessment to be able to appreciate if the refusal to take additional measure is compatible with the trajectory. And I think to have this appreciation, we have quite a few tools in our hands. We will have the possibility, first, of course, we will have the exchange between the parties and what the government, we will have to assess what the government sent us Monday. We will have to look at also what the other parties already sent us Monday and a few days before, and what they will respond to what the government sent us. And then we have the possibility to use a specific tool of investigation. We could convene a public hearing between the parties. We could ask amicus curiae to send their opinion to us. We could also send questions to experts. So it's a wide range of options. So I cannot give you more information now because we don't know. We have not yet decided on what kind of tools we will use. It will depend on the difficulty of the technical appreciation we will have to make. And this difficulty will of course depends on the credibility or not of what has already been sent to us by the party and what will be sent to us in the few weeks before us. Then you had a last question about the authority of the court to order action to the government, but I think that Justice Hoynck already responded to that question, and the Vice President in his presentation recalled that precisely we have in our power the possibility first to send injunction, which is order to the government, and to impose on the government penalties. And these penalties can be quite heavy, as we have decided on the last Friend of the Earth case. So I think we have really all the tools, and it's maybe a specificity of the French administrative judges, because this kind of power does not necessarily exist in other jurisdictions. It exists, for example, in the European Court of Justice, but it does not exist on other European legal system. So I think we have all the necessary power to be sure that our decision are correctly executed by the government or the local authority or whatever. I don't know if you if we have give sufficient answer to your question, and if you have other interventions or questions, we are of course at your disposal.
Thank you very much. We are going to take a few more questions, and again, we'll then turn to you, three justices, to give us a perspective. I want to turn next to another colleague and participant in our Global Constitutionalism Seminar, Manuel Cepeda. A professor now, was Justice of the Constitutional Court of Colombia. So Will, if we can unmute Manuel Cepeda, we can bring him on. While you're preparing that, I'll actually put another question to the group, and that is coming from Professor Christina Voigt. And she's asking, what do you think the international impact will be of your decision in the Grande-Synthe case? Do you think other courts will follow it? Do you think it will be seen as a breakthrough in climate change jurisprudence? But Will, do we have Manuel Cepeda available?
I do not see him in the attendees list.
All right, so we will go next to Corinne Lepage. By the way, Corinne Lepage is the attorney for the city of Grande-Synthe, that of course was the plaintiff in this case. Do we have her available, Will?
Yes, I'm trying to promote her now.
While we're bringing her forward, let me just say we did, as some of you know, start a few minutes late because of a technical difficulty. So we're going to run just a few more minutes to allow a couple of additional comments and questions, hoping that some number of you will be able to stay with us. Corinne.
Thank you. Thank you very much. First of all, I would like to thank Yale University and especially Professor Daniel Esty for giving me the opportunity to say a few words. The decision of the French Council of State is part of a logic initiated by the Supreme Court of the Netherlands and by the Supreme Court of Ireland. The legal basis, however, vary from one jurisdiction to another, since the French Council of State did choose not to apply the European Convention on Human Rights. You have the explication before. This decision, very important in France, carries two major interests for the development of other cases, since many cases have already been launched in the world, more than 2,050 according to the recent United Nations report for climate justice. First, the legal effect of the Paris Agreement, which is a universal agreement. Second, the specificity of the climate issue, which carries an essential spirit of legal innovation to face this vital challenge that we, humanity, have to face. It is a part of the construction of the law, which from national becomes international, because a common basis, human rights on the hand, Paris Agreement in the other. In this common basis, which make it possible to use the decision rendered in one country to consolidate the decision to be rendered in other country. And this gives a completely new mission, comparative law, that of allowing the construction of a law that is in fact universal, but on a national basis and no longer international. Thank you very much for your invitation.
Thank you very much for that comment. And I want to take just a couple of more comments, and then again, we'll turn to the justices. So in that regard, Jan Aguila, partner at Braden-Pratt in France. Jan, if you could come in if your microphone has been turned on. You're ready to go.
I don't see Jan in the attendees.
All right, how about Mathilde Otero-Boutonnet?
Let's see. Just promoted.
Mathilde, we welcome a comment.
I'm here, Dan. Do you hear me?
Yes, we can. Please proceed. Thank you.
Okay, thank you very much for all these very interesting presentations. I would just like to add a very brief comment. Of course, I think that the case of Grande-Synthe, the case of the century are both very important. But maybe it is also important to know that a few days ago, on February 11, a French court rendered its first decision in the Total case. Total, of course, the French oil company. And the judge recognized his jurisdiction. When he will examine the case, this could be, I think, a very important step in climate change litigation. The judge recognized, of course, sorry. Okay.
You're just fine. Please keep going.
Hello.
Mathilde, we can hear you just fine, so please keep going.
Hello? Hello?
Mathilde, we can hear you. I hope you can hear us.
Okay, sorry. Yes, I said that when he will examine the case, I think that it could be an important step in climate change litigation because the plaintiffs think that Total has violated the duty of vigilance. This French legal obligation requires transnational companies to put in place a plan, including due diligence measures. Among these due diligence measures, there is the obligation to describe how companies prevent environmental damage. This means that Total must explain how the company is preventing climate change. If the judge considers in the future that these vigilance measures are not enough, he could ask Total to take more appropriate measures to fight against climate change. Then I think that definitely that maybe, I hope that this kind of law, which requires companies to explain what they are doing to fight climate change, could be a key in climate change litigation for the future. Thank you, Dan.
Mathilde, thank you very much. I'm going to turn just in a moment to our justices for closing comments and responses to any of these comments or questions. One more that has come in on the Q&A from Anastasia Televsetsky, and she's asking, has the French government responded to the Grande-Synthe decision, responded to the Conseil d'Etat's order, and what have they said they are going to do in response? And with that, I'd like to bring in one more commentator live, if we can do it, Mims Wood, professor at the University of Oregon Law School.
Hello, thank you. It is an honor to be here. My question has to do with the growing number of cases worldwide addressing the climate emergency. The Juliana case, which is the American leading case, incorporated leading scientific declarations filed in the district court that show the need to return our atmospheric CO2 levels to below 350 parts per million. The path-breaking Grande-Synthe decision shows judicial resolve to hold government accountable, but it calibrates to the Paris Agreement targets, which envision a up to 2 °C temperature increase, which is deemed catastrophic by the Juliana experts due to expected sea level rise and the risk of triggering runaway planetary heating. So my question is, can there be an urgent judicial convening to provide a platform of exchange between judges around the globe confronting this climate emergency? Merci beaucoup.
Mims, thank you very much. And let me turn now, if I could, to the justices for comments, thoughts, reactions to any of these points that have been made.
Thank you. First of all, Chief Justice Lasserre had to leave the meeting. He had another meeting, so he's very sorry to have had to leave right now, but he sends his thanks for this webinar. There was two questions, I think. The first one was on how we envision the international impact of our decision. I think that we did not prepare this ruling in order to have an international impact. As judges, we are confronted with cases, with claimants, and we answer to these claimants. But then we were aware, preparing this case, that what we did at the national level could be or could not be duplicated in other jurisdictions. There is a paradox in this decision because we can see that there is a growing interest in the decision. And in the meantime, as Fabien Raynaud explained, we are mostly applying EU and French law in regard and consideration of the Paris Agreement, but really what we are doing is implementing French and EU law. We have, that's the point I tried to make earlier on in my presentation, you have different, in different jurisdictions, the situation of the climate change policy is different. There are some countries who have not yet set targets to reduce climate change. Some have made targets that might be seemed not ambitious enough. Others might make ambitious targets, but we are not sure they're in a capacity to implement them. So you have this whole array of situations, and I guess judges must respond to them according to the situation they have at the national level. So possibly the line of reasoning we had is one that is duplicable in certain jurisdictions if the national situation is of this nature. And to respond maybe to the last comment, normally, unfortunately, with the COVID crisis, we don't have many opportunities to discuss with colleagues from other jurisdictions as we would like to. But clearly, in a case like that, we have been reading a lot of cases from other courts, from other countries. In my opinion, I mentioned a number of cases from Switzerland, from Ireland, from Norway, from the Netherlands, etc., etc. And I guess that other judges in other countries will have the opportunities, if they want, to see what we have done in this case and see if it is something that can be emulates their way of apprehending the problem they have. But that's the way the Paris Agreement is built. It's up to national courts to make decisions. We don't have an international tribunal to regulate the way governments put in place the Paris Agreement. That's why we have such a burden at the national level of the courts.
Justice, thank you very much. And let me thank all three of our justices in France. We're very grateful for your time today. Please pass our appreciation on to President Lasserre, and we're very pleased with the chance to have brought this conversation to a global community. I'm looking at our participant list and see people from dozens of different countries. So although you didn't write this opinion with an eye towards international impact, it clearly is having one. And I do think questions of our future in terms of a society globally are going to depend in part on a judiciary that is willing to step up and push, as President Lasserre told us at the outset, for political accountability. And I think that question, of course, goes to what governments are doing, but also to what private parties are doing. And I do think we're going to see increasing push on companies like Total, as Mathilde was explaining to us a few minutes ago. So it is with some disappointment that we have to bring this conversation to a close. I'm especially sorry that there are dozens of questions now in the Q&A box that we won't be able to fully get to. And it's clear we could next time schedule this for a much longer block in order to get to greater depth on the range of issues that are being presented. And obviously there is enormous interest in climate change litigation as a topic. And I think there will be opportunities in the future to pick up the discussion we've launched today. So again, with thanks to our three justices from France, to my colleagues, Doug Kysar in particular for his lead response, also to our Yale Law School colleague, Patrick Weil, who helped organize this, and to Yves Guenin from the Conseil d'Etat as well for helping get this all set up. We're very appreciative. And then a special thanks to all at Yale who helped put this on, particularly Tyler Yergain, the Associate Director at our Center for Environmental Law and Policy. Once again, thanks to all of you for joining in the conversation today. We look forward to continuing this dialogue in the weeks and months ahead. Your participation and the action that you will help spur in your own countries across the world will be critical to our global community's response to climate change. Thank you very much. Justices, again, thank you. And merci, au revoir.
Merci.
Thank you.
À la prochaine.
See you, bye. Thank you very much.